Colonial Americans had already had a taste of what it was like to live under a government that could conduct searches anywhere at any time for what was considered illegal contraband. Often these search parties conducted the searches, confiscated property, passed sentence, and carried out punishments. Commoners lived in fear of these searches. The framers of the Constitution were well aware of the public sentiment toward this form of tyranny. So the Fourth Amendment was created, guaranteeing protection for all citizens against unreasonable searches and seizures.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Fourth Amendment, 1791.
The ambiguous wording used in the Fourth Amendment, however, did not provide a clear framework for what is considered a reasonable or unreasonable search or seizure. The most important criterion for determining that has become probable cause. This requires a law enforcement agency to have reasonable suspicion that a person or place is involved in illegal activities. Generally, they are then required to show the basis of their suspicions to a judge. If the judge agrees that there is reasonable suspicion, he or she will issue a warrant authorizing a lawful search or seizure. The warrant must identify a specific person or place that may be searched. It also lists exactly what the police are allowed to look for and the process they can follow when searching. In 1967, the Supreme Court helped define exactly what is protected by the Fourth Amendment in the case Katz v. United States. After police used eavesdropping equipment to record one of his conversations, Charles Katz argued his Fourth Amendment rights had been violated. The court agreed, ruling that citizens have a reasonable expectation of privacy under the Fourth Amendment. It also extended the zone of privacy to include homes, offices, person, and immediate public area. Automobiles and other vehicles do not have the same Fourth Amendment protection. Police are allowed to search any part of a vehicle as long as they have reasonable suspicion.
A person's mere propinquity to others independently suspected of criminal activity does not give rise to probable cause to search that person. Potter Stewart, 1968.
An exception to reasonable expectation is the plain view rule. This allows police to seize and use evidence that is found in plain view during a legal search. Another case, Terry v. Ohio, in 1968, broadened law enforcement's rights to conduct preemptive searches for evidence. This ruling paved the way for such preemptive searches as DUI checkpoints, border patrol searches, and airport screenings. The Supreme Court also ruled that students at public schools are not entitled to the same Fourth Amendment rights as other citizens. In New Jersey v. TLO, the court determined that school searches do not require probable cause, but must show reasonableness, a much less stringent criterion. In 1914, Fremont Weeks was accused of using the Postal Service to ship lottery tickets across state lines. However, police had entered his home without a warrant to seize the evidence they needed to convict him. Weeks appealed his conviction on the basis of his Fourth Amendment rights.
The Fourth Amendment protects the individual's privacy in a variety of settings. In none is the zone of privacy more clearly defined than when bounded by the unambiguous physical dimensions of an individual's home, a zone that finds its roots in clear and specific constitutional terms. The right of the people to be secure in their houses shall not be violated. John Paul Stevens, 1980.
The Supreme Court agreed with Weeks and ordered the evidence excluded from his case. Weeks v. United States led to the establishment of the exclusionary rule. Used as a guideline for courts to determine the admissibility of evidence, the exclusionary rule states that evidence that is not obtained within the scope of the Fourth Amendment cannot be used as evidence. For many years, courts have had an increasingly difficult time determining exactly what constitutes legal search and seizure and when the exclusionary rule should be applied. But as case after case during the 1970s and 80s was thrown out of court due to technicalities, many people began to call for changes, claiming the exclusionary rule unfairly hindered law enforcement and favored criminal protection. In 1984, the Supreme Court seemed to respond to this sentiment with its ruling in United States v. Leon. In this case, police had been told by an informant that Sean Leon was operating a drug operation in his home. Based on this information, the police obtained a warrant to search his home, finding large quantities of drugs. However, the trial judge determined that the affidavit used to obtain the search warrant contained insufficient probable cause, so the judge would not allow the evidence to be introduced in the trial. Prosecutors appealed the ruling, arguing that the police believed the warrant to be legally granted, and thus seized the evidence in good faith. The Supreme Court agreed, creating what is now known as the good faith exception. The court further stated that the exclusionary rule sometimes is costly to society. As in U.S. v. Leon, where a guilty man would go unpunished, the use of the exclusionary rule could cause society to lose respect for the legal process, and police would be handcuffed in future investigations. While many people applauded the court's decision, civil libertarians were angered by what they viewed as an unfair limitation on the Fourth Amendment. They did not want the government to have expanded power to obtain evidence because they feared the government could target any group or person that disagrees with it. The reach of the exclusionary rule continues to be contested in the courts and also continues to be a topic of public debate.
We are unwilling to send police and judges into a new thicket of Fourth Amendment law to seek a creature of uncertain description that is neither a plain view inspection nor yet a full-blown search. Antonin Scalia, 1987.
Now, with the Internet, more Fourth Amendment issues have arisen. The Patriot Act of 2001 allows anti-terrorism teams to monitor email and Internet traffic in order to prevent terrorist attacks. The government argues that cyberspace is public domain and that no warrants should be needed to access information. But civil libertarians claim the privacy rights of individuals are being compromised.